All right. Hello, everyone. I'm Lisa Twilley. I'm the director of the Women's Business Center here at Maryland Capital Enterprises. Just to give you a little information about us, we are a nonprofit based here in Salisbury, Maryland. We also have an office in Baltimore City. We cover all the Eastern Shore of Maryland, Baltimore City, Baltimore County, and Anne Arundel County as our service area. We provide business consulting, marketing consulting, educational training workshops such as this, and also small business loans. So if there's anything we can assist you with please reach out. I put my contact information in the chat, and I know I have a couple co-workers on here today. We have Marvin, Donna, and Nick, so they'll put their information in the chat as well. Donna and Nick are located in Baltimore, so if there's something you need assistance with, please reach out to them. And we do have a couple classes coming up, and one next week, which is building your marketing strategy. And that's October 26th from 6:30 to 7:30. It's actually it's going to be a hybrid event, so in person here in Salisbury, but you can join us virtually as well. And then we have couple more things coming up in November, and I'll put the link in the chat for those as well, so that you can just copy that and click on and check those out. So today we have Jim Peterson. He is the Vice President of Commercial Banking at M&T Bank, and he teaches quite a few classes for us, and we love having him because he does such a great job. And I know he has a guest speaker joining him as well, so I'll let him introduce him to you. And thank you guys for joining us today.
Hey, Lisa, thank you for having us. Is my guest host on?
He is. I believe that's him, yes.
Tariq, you with us?
Yes, I'm right here. Yes, sir.
Hey, good morning. How are you?
Good. How are you?
I'm doing fantastic. So I'm Jim Peterson with M&T Bank, Vice President of Commercial Banking and Small Business Ambassador. All of my contact information is now in the chat. So you feel free to connect with me on social media or on LinkedIn. That's the best way to get a hold of me. You can call if you like. I promise to get back to you eventually. But the easiest way is to email or connect with me on LinkedIn or my other social media. It's just easier. If I'm in a meeting, I might be able to hit you back. So today we're going to talk about patents, trademarks, and copyrights. And I do have a standard traditional program that I usually go through, but I thought what better way to answer all your questions than to have a patent agent, a licensed patent agent, friend of mine, Mr. Tariq Najiullah. Please, sir, introduce yourself.
Thanks, James. So my name is Tariq Najiullah. I'm originally from Atlanta, Georgia. I have a company here, Patent Insider, that saves businesses from intellectual property disasters here in Baltimore, Maryland. But you know, my clients are international in reach. I guess I'll stop there. Jim, let me know if I need to go further.
Yeah, well, we'll dig a little bit because this is a new audience for us,
Okay.
Right? And I want the audience to get to know you. So you said you're from Atlanta originally.
Yes.
So what brought you to Baltimore?
I actually came here to Baltimore after doing some study abroad after college. Worked in the nonprofit sector, actually. I was working in Park Heights, doing community redevelopment, working with, forgot what's this, O'Malley and Ehrlich was the era, so it's a little while ago, but that's what brought me to Baltimore, doing some nonprofit work. That's how I came up here.
That's amazing. That's amazing. So what does your company do exactly? What does Patent Insider do?
So Patent Insider, like I said, we save companies from IP disasters. What does that mean? So their businesses started every day. Hundreds of thousands of businesses started every day, and also hundreds of thousands of businesses shutting down every day. Sometimes these businesses shut down, a lot of times because they don't have the money or the capital to stay in business, but also sometimes they shut down because they didn't protect their assets. And when I talk about assets, I'm not talking about properties per se. I'm not talking about money in a bank account. I'm talking about their ideas. The intellectual property assets. These are called intangible assets. On a balance sheet at a bank like M&T, when you run a balance sheet, a company's going to have assets. They're going to have ideas. They're going to have policies and procedures. They're going to have their brand name. They're going to have innovations and inventions, things that they have that they need to protect. And so what my company does is we work to develop a bulletproof intellectual property strategy. And if you have patents, we help to make sure that you have a bulletproof patent strategy and implement that strategy for you. That was a lot quickly, but does that
No,
capture?
that's good. That's exactly that's what I was looking for. Now I'm going to ask you again. We want to get to know you. So why do you do this? You know, why did you stick around here in Baltimore, and why did you decide to start this company here?
So this came out of, you know, I would say, necessity is a mother of invention, right? So I met my wife and got married. She's a grad student at Howard University. So I stayed in the area. That's really what kept me here. But you know, to get a better job in the nonprofit sector, I worked at the patent office. I'm an engineer, worked at NASA in the past. So I got back into my training, and at the patent office, I learned, you know, how to, you're becoming a patent examiner, we examine inventions. So by examining inventions, if you have an idea, you submit it, goes to the patent office, we beat up on it, see if it's new, and if it is, then we make sure that we give you a stamp of approval. If it's not, we reject it. And sometimes I think they reject so much, people say it's a patent rejection office. But the point is to preserve the rights for the public. We want to make sure that you have something new. We don't just give patents to anyone. So I did that for 10 years. And in that space, I got to see that, you know, working with different patent attorneys, I got to see where, you know, there was opportunity for business because everyone didn't have the best interest of the client. They were milking the process, but there were many opportunities to get, you know, a patent or secure intellectual property for an inventor or innovator that's moving our economy forward that was not necessarily, that wasn't taken advantage of. And so being the entrepreneur at heart, I took a leap of faith. I took the patent bar exam. I became a registered patent agent, and I started using what's I call patent insider, my insider know-how, learned from being at the patent office for 10 years to take that expertise and use it to help clients, business owners.
So you used a word that a lot of people, when they think about patents, they probably will use as well. And you said new, right? So what exactly does new mean to a patent agent, right? Is it something that's never ever been created before? Is it a new way of doing something? Is it a new color? What is new?
So this word new has different meaning depending on the type of intellectual property we're talking about. So when we're talking about a business, you're talking about a brand, you're talking about building commerce. A good thing to do is take an inventory of what exactly you have. And we think of inventory, we think of, you know, oh, I have this calculator or whatever else I have, you know, in my office, my glasses. We take an inventory of things, but our thoughts, our intellectual property is just as important. You need to think about, you know, what type of content do you have? What type of compositions? If you're an artist, so, and the reason I say I categorize it like this is when to categorize different ways you can itemize your ideas or your creations, and then there are different types of legal tools to protect them. And each of those different legal tools have different meanings that connote new. Like what, so for a patent, for example, a machine, article of manufacture, composition of matter that is novel and non-obvious can be patented. Novelty is a patent in patent law refers to something that is totally brand new, or it's an improvement on an existing product or methodology. So people say, you know, can you build a better mousetrap? Yes, you can build a better mousetrap, and you can actually get a patent on the better mousetrap, not on the mousetrap concept in and of itself, but the part that's better, the improvement is qualifies as new. So that's that. But I can come back to the other part as we go through this. I don't want to.
Yeah, no, that's good. That's good. So I know that I work with a lot of folks who, you know, in that tech space or trying to be in the tech space, they're creating apps and platforms. You know, what does somebody in that space need to think about protecting?
So,
because it's easy now, right? You can, you know, there's apps to create apps, and you know, and there's no code, and you know, so everybody's got an app. But you know, if it's truly unique, and what do they need to be thinking about?
So I would say that when it comes to applications, software applications, so what is your niche? What is the actual thing that is valuable that people are going to buy? When you think about it, you have an app has, you have content within the app. You have the platform or the software, the backend behind the app. You have the name of the app. You have maybe a logo or image or artwork within the app. So what's the most important thing? Like, I'll give an example. Like we use, let's say, Instagram or TikTok is a popular app. So TikTok, so TikTok has a logo that can be protected by copyright. You have TikTok has a name, a trade name that can be a trademark. It has a software platform that is different than other software platforms, that has maybe some different software architecture that may be patentable. It has maybe some trade secrets, some algorithms that how they galvanize information and make things move along that also may be patentable, or maybe something that's going to be a trade secret. So when we're looking at software, the way I think about IP, I think of IP in terms of 3 pillars and across 5 different risk areas. So you want to analyze those 5 different risk areas for every type of business or product or it's a software application, and you want to look at those 5 areas to make sure you're covering yourself. We can talk more about that, but did that answer your question?
Yeah, that's pretty good, because a lot of people need to start thinking about those things. And it's funny you should say TikTok, because I just heard recently that they're starting to sell things, and they're going after Amazon, and TikTok is amazing in my opinion, and they're a privately held company, so they can pretty much do whatever they want to do. So that's a pretty serious example there. I admire them, even though I don't, there's reasons why I don't, but as an enterprise, to be able to compete with Amazon on the level that they're going after, that's impressive. That's impressive. And I'm sure some of the folks on the line who have those kinds of aspirations could relate to that. So you're a patent agent. Can you explain to us what the difference between a patent agent and a patent attorney is?
Okay, yeah, definitely. This is something a lot of people get confused about. So everybody knows an attorney has to go to law school, has to pass a state bar exam. And so when you graduate from law school, you get what's called a Juris Doctorate, a JD. When you pass the bar exam, you become Esquire, you're able to practice per that bar association within the state. And usually you can get reciprocal representation across straight lines for certain cases. But none of that makes you a patent attorney. To be a patent attorney, you have to actually study a certain section of the law, patent law. You have to have a certain technical background, either engineering, life science, certain level of acumen in the technical sciences. And then you have to sit for the patent bar exam, which is called the patent registration exam. So a patent attorney takes a separate bar outside of having a JD, outside of taking a state bar. They have to sit for the patent bar. Now, there's an exception, and this goes back to the way the patents were done over many years. It's one of the earliest offices, in American history, or government agencies. And what happened, they allowed for technical experts to take the patent bar, basically become registered. So we're able to draft patent applications, prosecute patent applications before the patent office, and be agents before the patent office. So we have the same qualification that a patent attorney has to do with patents before the patent office. There's no difference in that qualification. Once we step outside of the patent office, we're citizens. We don't have a JD. We don't necessarily have, pass a state bar exam. So, what I like to think is that we are focused on a certain aspect of it. So we don't muddy the waters. We're not necessarily focused on litigation. We're not focused on, we can't do it. We're not focused on, a bunch of billable hours outside of dealing with patents themselves. And so I like to say focus is our superpower. We're able to focus. We're often the people that law firms hire to actually do patent work. So
Okay. Good. Thank you. Thank you for that. So two more things you said. You mentioned patents and trade secrets. So what might somebody be more apt to patent, and what might somebody be more apt to keep as a trade secret? First of all, explain what a trade secret is. People might know what a patent is, but can you explain them both, define them both, and then maybe give some examples of one of each?
okay, so yeah, so there are 5 typical areas of risk areas of intellectual property. Talking about these particular ones, so I talked about a patent, a machine, an article of invention, a composition of matter. All of these are things that can be patentable. So you think about a device, like I have a stapler here, a calculator, a software application, a microphone, a new drug, a new type of fertilizer, a new shoe, a new type of fabric for clothing, a synthetic silver. All these things can be patented if they're generating new technology that can be patentable. We're talking about a trade secret. So this is, think about things that this is something in trade, something that's your competitive advantage that you keep to yourself. So think about this. We all drink Coca-Cola, or we had it before, or Pepsi. We don't know the recipe. The recipe has been kept as a trade secret. Another example would be Kentucky Fried Chicken's KFC's 11 herbs and spices. These are 11 herbs and spices that you can buy at the grocery store. But what are they? And how do you put them together? Now they have people that, I actually know someone who's this type of chef who can eat something and tell you the ingredients and replicate the recipe. That's a very special skill. But for most of us, we just eat it and, oh, it tastes wonderful. We don't know the 11 herbs and spices, and those aren't patented. They aren't trademarked. Maybe the phrase 11 herbs and spices is, but it's kept secret because if I give it away, then everybody can duplicate what I have. And even if they do know how to duplicate what I have, I'm not going to affirm it by telling them what it is. So that means the key idea behind a trade secret is that certain things, certain types of intellectual property can be protected by legal protections. There are legal tools to protect it. Some things cannot. And the only way that you can actually protect it is not saying anything, not telling anyone. And if you do, like if you have people that work in the lab at Pepsi or work at KFC making the seasonings or the mix, then you have very ironclad non-disclosure agreements, non-compete agreements that you tie these people up in so that they can't disclose it without risk of suit or something else. But then I know there are some, like I know I went to the world of, I'm from Atlanta, so I went to the world of Coca-Cola, and when I went there, they don't even trust people that much. They said we have like 5 scientists around the world that think they know the recipe, but they only know part of it. They don't know the whole recipe. They had to all come together in a room, and they, there's some dummy ingredients in it. When they all come together, they can make it. And so, and that could just be all hogwash. I don't know, but I'm saying that's part of. It's just knowing that the principle behind trade secrets is that some things you keep close to the vest. There's no other way to protect it other than not telling anyone.
And if I'm not mistaken, in the law, it says if it's a trade secret, you're obligated to do everything possible to keep it a secret, correct? I mean, you can't say, well, this is our trade secret and then hang it up on the wall in your office, right?
Exactly. That would be,
yeah.
That would do the whole point.
And then you're going to sue somebody for stealing it and you got it sitting on your desk or something like that, right? So, yeah, thank you for that. That's pretty good. So so again, patents. What are the different types of patents, right? Is it the same patent for a piece of clothing as it is for that stapler that you held up?
So there are 3 different types of patent applications that are categories of patents that can be obtained. So one would be, we talk about like if you're developing a new plant, and this would be for some, in the part of Maryland, we have our agricultural areas where if you're, through science modifying plants to produce a new species of plant, then you would send that sample to the patent office, you apply for it, and if they can validate it and verify it, then you have a patent on that particular strain or biological product. So that's called a plant patent or biological patent. That's actually as a repository of these seeds and different things at the patent office that they qualify. So that's I would say this one that's not as well known, but that's one of the categories. The other categories we're probably more familiar with is called a utility patent. A utility patent is for everything from the software application to the stapler to the calculator to a ballpoint pen to a telephone. And so that's the second one. I have for the next one. I want to show you a prop here. So I have this book here. This is I'm a patent nerd, right? So this is called Patented, and it has 1,500 or 1,000 design patents. So design patents are things that I don't know how well they're coming across, but I've had this posted.
Can get a little bit. All right.
These are everything in here from you have airplanes. These are shapes, Ouija boards, beverage cooler dispenser, a Coke bottle, the original iPhone, the original light bulb. All of these things are in here, but these protect the shape and aesthetic, so the look of something. So a Coke bottle is patented. The actual shape of it and the design of it, that is patented. At this point, it's public, domain. This thing says from, it gives earlier dates. So some of these things are old, but for the most part, these give you a limited monopoly for, 15 years for design patent, 20 years for the other types of patents. And that covers you for a period of time to have a limited monopoly. Like for instance, the iPhone, the original iPhone, the patent has expired. But if you notice the iPhone, Apple comes out with a different iPhone every 6 months. And people think, why are they doing this? I don't know that every phone is better. They just put a new camera in it, or I don't know, I don't know. It looks like the same phone. Maybe they change the lens and the camera, something like that. But what they're doing also is they're increasing the intellectual property. They're expanding or broadening the range of it. So they might file 1,000 patents for every iPhone, for every iPad. And so if they expire, design patents expire every 15 years, utility patents every 20 years, they're extending the life of that original IP, because that original iPhone patent is dead. The next generation, the second generation iPhone, the third generation iPhone, those patents are dead. But they're still able to move it forward. So this is also showing you that in today's time, perpetual protection of your intellectual property also broadens your rights and your scope and your ability to do things and leverage that intellectual property.
Yeah, does it help you defend your patent? Like if you have a patent and you stick it in a drawer, right? You went through all the expense and had somebody write it for you. They hired you and you got them a patent. And then they stuck it in the drawer and did nothing with it. And somebody happens to start doing the same thing. Do they again, are they weakening their position to defend that patent if they're not even utilizing it?
Well,
or it doesn't matter.
So yes, they are weakening the position. A lot of times that happens because, when I look at intellectual property across 3 pillars: getting a patent, getting a trademark, getting a copyright, getting any of these things is just part of the picture. That's getting your paperwork in order, pretty much. You're fortifying your intellectual property assets. You're getting intellectual property tools to associate with your IP assets. That's it. You're not in any way, shape, or form considering the other aspects. What are the other aspects? Well, the second pillar I like to refer to as enforcement and defense. Now that you have these rights, how do you enforce them? How are you going to defend them? A lot of times it's done in a courtroom. Do you have a patent litigation attorney? Do you have a patent litigation team or IP litigation team to enforce and defend your rights? Do you have litigation insurance? There are companies that will give you litigation insurance based on the market, based on your positioning. And it's the insurance premium. You pay a premium, you get so much coverage. With the average cost in the last report from the American Intellectual Property Legal Association saying that $3 million is the average IP expense for litigation. So, and that's not just one case, but multiple cases. And do you have a plan in place? So that's a big piece of it. The third pillar I like to, is also, and we see this when we look in the news, we see different, I'll talk about this in more detail if we give me another question, but there's another pillar that's also very important to consider. How are you going to make money off of this? To commercialization. How do you leverage your IP? Are you going to use it to sell products, or are you going to use it to, leverage it for a licensing deal? And I have some different,
Well, let's go there. Let's go there, right? So I've heard you talk about, the cost of a patent. I heard you talk about the cost to defend a patent, which is on average $3 million.
But that includes the big guys and the little guys. Maybe not as much
Yeah,
for the little guys.
I get it, but still, it's a lot of money, right? Yeah. It's a lot of money to get a patent, a lot of money to defend a patent. Who should get a patent, right? If I have a new idea for a particular item that's going to sell for under $100, should I be patenting that item?
It depends. So a lot of it depends. So a lot of people will, and this is business owners who come in and get IP protection in case something happens, but not have a plan to do anything with it, or go to see someone to get help when something happens. Oh, I lost my social media handles, all my name. I've built this brand for the last 10 years. I had 150,000 followers on Twitter or Instagram or whatever it is, and I was selling my product. I lost my Instagram shut it down. And then someone else has my name because they have a trademark. Oh, I should have trademarked my stuff. And you can, negotiate, rebrand. That's a cost to that. So there's always a cost to doing something, a cost to not doing something. I think looking at this is more so looking at the big picture. How much does your IP, if you're just selling another, like you open an insurance company, you're an insurance broker for a big name insurance company. That insurance company is trademarked. They have their IP protection. If you're not doing anything unique, you're not offering anything that's, unique content, unique branding. There's no unique innovation that you're bringing. You just, in that service business, you don't need any IP protection per se. Now, but if you are in that same business, but not only are you working, as a, insurance agent for a larger company, but you're building out your brand. You're building on a social media brand. You're building on a content brand on YouTube. You have your own podcast. You have your own shows. You need IP protection for all those things to maintain them. And whether or not, so I'm saying whether it's the product itself or whether it's the brand, the image, there's content protection. And we see this with musicians all the time. I think the popular guy, Kanye West, is in the news all the time now. One of the things is about he had a deal with Adidas and Gap, and it's quote unquote a billionaire, and he's lost the deals as well for having saying some very horrible things in public and having just a very interesting personality. God help him. But the point that I like to look at from my perspective, this is an IP deal. All of his money has been made on intellectual property. First, as a producer, he's making beats and writing songs as a composer. His money, that's a copyright that he has to sign and get. That's published. They call it publishing in music, but that's his copyright. He's getting paid from his intellectual property contributions and copyright. That's where he makes his money. As a music artist, the same thing. He's getting his money. The deal he signed with the record company is signed against his intellectual property, his music compositions. That's an IP deal. When he works for Adidas as a creative director, he says, hey, I'm making these shoes, I'm doing these things. Okay. His concepts, his artwork, that could be design patents, that could be it's creative material. He's exchanging that for money. It's commercialization. This a deal with Gap, fashion. And whether you like the fashion, I'm just saying that this is leveraging someone who's become a billionaire off of a lot of things. I'm not going to try to figure out why, but the music, it's someone who's leveraged intellectual property and commercialized it in a way that has led them to a level of, financial success, sophistication, maybe not as much, but definitely financial success in terms of, public figure. So I would say that, you want to think about where you want to go and how you learn how to protect that intellectual property you can leverage it, and there are different things you can do. There are tools to your end. Well, what you're in, where do you want to go is what's most important. Whether, for me, I can't tell you what exactly you should protect or not. Where do you want to go? And if you're going in a certain direction, I can say, well, you probably need A, B, C, and D. You might want to, if you're going to build a brand, you might want to check into a trademark. If you want to build a brand, you might want to look at the copyright. If you have a logo, you might want to trademark that. If you have, 20,000 followers and you're growing a following, you might want to, trademark your social media handles. That's valuable. That's how you make your money. You want to protect that. You want to make sure somebody can't rip it off. You want to protect your hashtags.
So I've heard some people say that, well, I was on there first, right?
Okay.
Or I started my, I used that name first on Twitter. And I used everybody knows I had that name on Facebook first, right? How much security is there just because you were the first one with it?
Unless you take action, you can be the first, but if you don't take action to protect it. So the way, and this is, if you've heard the phrase in law, ignorance of the law is no excuse. Law says that in intellectual property law, if you do not take any action to protect yourself, then you're just giving it to the public freely.
It's kind of like that trade secret we talked about that you hang on your wall. Right?
Everything that you, like if you sell so for instance, what prevents you from getting a patent? If you sell a product, and within 1 year of me selling that product, I take no action to get a patent, I can't get a patent on it anymore. Because I've made commercial use of the product, and there's a grace period. Really, upon commercial sale, you're barred from getting a patent. There's a grace period for 1 year. If you're the one that's selling it, then you're allowed a grace period of 1 year to apply for a patent. But I have people say, well, I've been selling this product for the last 5 years, now I'm ready to get a patent. They're like, well, you can't get a patent. Yet you have a 1 year grace period. Now, a trademark is different. I can start with a trademark. If I can prove through evidence, I can apply at a later date. But if somebody's applied before me, then I can't go through the traditional route. I have to then go through, I have to conflict with them. There's a whole interference and process, which I've experienced that and worked with some people on that. It's not a fun process. It's better to take care of it first, especially now that the USPTO is first to file for patents. And for trademarks, if you can prove evidence of use prior to the date, you can backdate. But you can't, what if you backdate and someone comes in and challenges you, they have a previous date, you can't go back and edit your back. I mean, it can get messy and you spend way more money trying to correct it than just doing it right the first time.
All right, so we got a question in the chat. Pete wants to know that getting the patent can be expensive. How do you balance earning enough money with the patent to pay for filing that patent?
So there's some questions here, Pete. So is that your goal, objective, to make money on the patent, or are you making money on the product? Or are you making money through sales in your business? The patent in and of itself makes you no money. The patent is a protection that protects your either utility of a certain innovation or the design and aesthetic of a particular design. If you're making money by selling the product that's designed that way, like Apple's not making money off of the iPhone patent per se. But remember, going back, and this is like, we have M&T Bank here. So a bank, you have a balance sheet. You have the assets and liabilities. On the bottom left, you have intangible assets, right below your inventory, everything else. It's going to be trademarks, patents. These are expenses in the beginning. They're investments. But as the company grows, it's just like if you have a company and you have stock in your company, but you're not a publicly traded company, you're a privately held company, that stock has no value. But if the company makes a lot of money, then the value of that stock increases. The same is true for the patent. So a patent becomes independently an asset. And I can take out a loan against that. I can license it out. Like if I build a huge brand name, I can license my technology or license my patent to, I can develop that as creative as I want to do. I can license to Baltimore City or to Salisbury, Maryland. I can license it to a company there to use it in that particular space, and then license it to someone else in Baltimore, and license it to someone else in Washington, DC, and license it to someone else in Laurel. You can have a chain of things. So that Does that answer the question?
Yeah, Pete put his hand up. So Pete, you can come off mute and if you had something more to say to Tariq.
Yes.
Yeah. Yeah, no, thank you for diving into it. I feel like this is a classic startup kind of issue where you've got like a idea for a new venture and you're trying to build up enough of a brand and enough of a business to be able to be sustainable. But you might be in a space where somebody else can look at that and say, oh, that's awesome. I've already got, all this money and all these people and all of these things. I'll just do what you do. And then I'll take your customers, and then you never get off the ground. And so it's that balance between, building enough of a brand to be able to make the money to pay for the patent. If you don't have the money up front to pay for the patent is to protect you while you're still building your brand.
So this is, we work with startups a lot. We work with Tedco here in Maryland. And one of the things that, so there's certain companies where your whole competitive advantage is based on IP, right? You can't afford not to have a patent. So you have to, there are things you can do. But what I tell people, you don't want to necessarily get a cheap patent because it's like having no patent at all. Because it doesn't protect anything, because you wrote it yourself, maybe you did legal aid, maybe you went to a university and had, the students work on it. I mean, it's going to maybe be better than if you did it by yourself, but it may not protect, it may not be strategic like you need it to be strategic for what you have. What I tell people is that sometimes, you need to look at what's more important is looking at what's the market for this? Have I done focus groups? Is there a way I can make money on what I have now? Can I provide, in software, it's the MVP. Can I provide an MVP level service that doesn't contain all the bells and whistles of my innovation right now, that I can sell and make some revenue, that I can sell investors on, that I can raise capital with? And so that with this capital raise, I can invest in some initial IP. Number one is IP is iterative. It's not one and done. You're not starting and I get one patent that's going to save my life. Like I told you, Apple has 10,000 patents on the first iPhone. So, that's design patents, that's software patents, all kinds of patents, right? So that's the hardware. That's how the software works. That's the operating system. So all of that is covered from every angle. It's very strategic. They carve out a market with their patent filings, actually. So now they're only compared to each other. They're not compared to anyone else. They've created a whole niche. And that can be done, if your startup, can be done by filing, maybe you allocate to file a patent a year. I can squeeze out, $10,000 to invest in IP. I'm going to do some strategy analysis, and each year we're going to allocate that until we get to a point where we're allocating, $50,000. But you have to start somewhere. I want to get back to you, Pete. There's another question here that says, do you trademark the name of a restaurant? Yes. Wendy's, McDonald's, Applebee's, name a restaurant, trademark usually.
So do we have any other questions from the folks on the line? Because Tariq and I, we do this all the time. We can talk forever. If you want us to just continue, we can certainly. I got more questions and he's got more answers. So what I would say, Tariq, is can you give us some examples of some well-known companies that we might know while we're waiting for some more questions?
So like I always I'll give an example of, so there are two examples I like to give. People don't believe, they're like, I don't believe that. But there are two examples that I give about software that, actually three, but I'll kind of run through them, that lets you know the importance of protecting your IP. So one, this is called the hard story. So Clubhouse. Clubhouse, who's heard of Clubhouse? Okay, so Clubhouse is a social media application that just had the right timing for the pandemic, and it's an audio social media app. So we're basically talking to playing party line on the telephone, but it's through a social media app. And they got a $4 billion valuation. If anyone understands a cap table, that means they were able to value their company at $4 billion and raise money against that valuation. Doesn't mean they had $4 billion in the bank, but they were able to raise money against a valuation of $4 billion. So they were highly capitalized coming out. And right when they were really launching that year, they got sued. What did they get sued? They got sued by a company because they didn't have a trademark. They got sued by a company called the Clubhouse app. Believe it or not, there's a company that actually filed a trademark, has a software application called the Clubhouse app. And this was for sports executives in the they worked in the baseball, baseball, the locker room is called the Clubhouse. These are front office and management types that is a social media app for them, and also a job app as well for them to get jobs. And so right after they announced this big valuation and then launch of Clubhouse, the next story is Clubhouse sued, then Clubhouse reached a settlement. I don't know how much the settlement cost, but the settlement was definitely more than what it would cost the $5,000 to get a trademark.
Right.
Now the same thing,
I bet those Clubhouse guys were just waiting, right? They were just waiting for that valuation to come out or whatever. And
I don't know, but the other thing though, Clubhouse, they didn't, it wasn't just trademarks, they didn't file any patents. So if you notice, LinkedIn has a social media audio app, Twitter has Twitter Spaces.
Right. So
Slack,
everybody stole it.
everybody's using it. The
And
exact
they got
things
sued.
they developed are being used by everybody in the social media platform. They have no patents. So
Wow.
that 4 billion, I mean, I don't know what the valuation is now, but you have to get that
Probably $4.
So, not protecting yourself and, having a laissez-faire attitude towards IP can cost you. There's some more questions here. Do you see?
Can you share the pitfall or landmines to look out for when entering into an agreement? Example, licensing with another company who filed a patent on a technology or patented it first.
So these things are all about leverage. I try to give examples. Anybody heard of Michael Jordan? Anybody?
Yeah.
He's a really great basketball player. So he's made most of his money from not from playing basketball. He made most of his money from intellectual property. Now, the thing about that, it's all about leverage and licensing agreement. Michael Jordan in 1984 signed a deal with Nike for $500,000 for the iconic Jordan brand and to do the Air Jordan 1s. Now, we don't have the exact numbers, but it's been estimated that Nike made as much as $100 million off of Air Jordan 1s. Michael Jordan had to sign his name, likeness over to Nike for $500,000. Now that agreement was amended and it's gone on. At this point, Michael Jordan has made $1.3 billion with Nike, maybe a little bit more because that was reported in 2020. But Nike has made like $40 billion, and he accounts for over 70%, maybe 68% of their sales, the Jordan brand. He's a shareholder. He does not own the Jordan brand. He's a shareholder. Nike owns it. It's all an IP deal that was signed back in '84. It's been amended, and he makes 5%. Now, the 5% made him a billionaire. But that's understand when you make in Nike, out of all the other, they have hundreds and hundreds of athletes, football players, baseball players, all kind of basketball players, all kind of athletes, track in the field. All those athletes together don't make more than what Jordan brings Nike.
Wow.
So that's an IP commercialization deal. And he had the best agent. He got one of the best deals ever at the time. But he also created a market with his success, has allowed them to take hundreds of athletes on. And he didn't know that in '84 that was going to happen. And I'd say he made out good. He's a billionaire. So it's not like he's hurting. But when you look at, he's responsible for creating a whole stratosphere of sneakers and
Clothing and a bunch of other stuff.
That now that a company like Under Armour can come behind that and make a business out of following the same model. Or, Adidas and all the other companies are following the same model that he built with Nike. So it doesn't protect you from everything, but it does give you, he is making money off his IP rights. So you have to look at the leverage, read the fine print. And then I would say that you have to be very careful. But if you're the little fish in it, you're not going to make more than a big fish. It's just not, doesn't. And that's why I gave the Michael Jordan example. He didn't make out bad, but Nike's still making a killing.
So the big guy's always going to make the most. You just got to get the best deal you can get.
Right.
And we would advise you to get some assistance with that. Right?
You need an attorney. Like,
Get an attorney. We are not attorneys.
Right.
We should have put that disclaimer out on my other presentation. That's the first thing that shows up, is that I'm not an attorney. I'm not pretending to be one. This is just, you know, advice at this point, not legal advice. But soon, I hope that answered your question. Basically, get some help with that. But again, the big guys are first of all, they're going to have attorneys themselves, and you should too. So we have another question from Pete, and Pete, you might want to come off of mute and have a conversation, because you get a lot in there.
I think before Pete, there's one. Demetria Scott said,
Did Dimitri have one? Okay.
What type of protection should be sought for business taglines? What I need more clarity on what you mean, Dimitri. Could you share that off mute, please?
Can you come off mute, Demetria?
Hi, thanks for answering my question. So business mottos and slogans like Nationwide is on your side and things like that. How would you protect something like that if that's what your business utilized and that was a part of your business identity?
So there are a couple of different things you can do. Like you can trademark a sound. So let's talk about it. We didn't necessarily talk about this in detail. The difference between a copyright and a trademark. So a copyright protects something that you've composed, artistry. So think about it, being an author of a book, being a musician, a composer of music, being an artist, painting a painting, taking a photo, writing musical notes on a composition. You can copyright that jingle, Nationwide is on your side. This is just for content ownership. So who owns it? Who's the creator of it? That's different than a trademark. A trademark is for saying in the marketplace of insurance, Nationwide is on your side is our jingle. So that's a sound. That's a slogan. So that's a trademark, slogan, trademark model, but also the sound, the jingle, the Nationwide is on your side is also a trademark. The logo and image, the name Nationwide, all these things are within the marketplace of insurance or services, based professional services, that this is a registered trademark. And so I would say start by putting TM, which is saying that you intend to use what you're using as a trademark. But also that provides no legal protection, but it does notify the public saying, so you can go back to that date when you started putting the TM or started using it, saying this is my first use. And then I notify the public when I use it, I was intending to use it as a trademark, not just as words. Like here, I have Patent Insider, I have TM here, but also this is a logo, but I have a word mark. What is this? I have a registered trademark for Patent Insider, right? So Patent Insider is a registered trademark for our business. And so that's the word Patent Insider is a trademark, but also, so the next thing we need to do is apply for the logo, get the logo trademarked. If I have a hashtag that I want to protect, the hashtag being trademarked. So does that make sense? So I'm saying copyright is for content ownership, for attribution, for who created something. And a trademark is specifically for in the business marketplace for your particular market. And an example I use is like you have Delta Airlines, right? Delta is a trademark. Delta water faucets, Delta is a trademark. Two different Deltas, both have trademarks for their different markets. So you can have the same name as someone else if it's in a different marketplace. Does that make sense?
That does. Thank you so much. That was really helpful.
Yeah, back to Michael Jordan. I remember he was being sued by a restaurant or something. There was a gentleman who had the same name and called his restaurant Michael Jordan's. And there was some legal back and forth between, I think either Nike or Jordan, one of them wanted to like shut him down or something like that. And he was saying, well, my restaurant has nothing to do with your shoes. And I don't know how that washed out, but I remember the argument.
Right. So, and that's one thing. You'll see this sometimes. I think I was thinking of Beyonce and Jay-Z's daughter, Blue Ivy. They want to trademark her name, and they're like, "Well, you can't trademark the name because she has no business attached to it." But the idea is that if your name becomes a trademark, then anyone using that name, they can't necessarily. You do have rights over that. And a trademark is national. You can also get an international trademark through Madrid Protocol. So. You just be unfortunate to have your name be Michael Jordan. And that's
Right.
why if you notice the actor, he goes by Michael B. Jordan for that same reason, I'm sure.
Right. I'm sure. So Pete, let's circle back to you and see if we can wrap up with your question.
Sure. Yeah, if there's nobody else in front of me. First off, thank you so much for the advice. I mean, basically what I'm hearing is develop a fund to run IP. And basically what I was listening there in the chat is I'm already in a space where I'm going to like conferences and trying to get new business by showing them a little bit about what I can do in presentations. And then I go and see my competitors in the space using my content without attribution. So I'm trying to be very careful about, trying to get some rights on it, but, I have to be able to make the money and live and survive, and then file to protect that so that I can make more money in the future. So I'm just trying to see if there's any techniques to get ahead of that.
You have to make the investment. Like there's no, I know it's a cliche term, but there really are no shortcuts. If you intend to protect, make money off of what you're protecting, you have to invest in protecting it. And that doesn't mean like people say that means, get a second mortgage and invest all I have into it. No, you need to start where you can. So there's some things you can do. There's some things you can do yourself. Like you can get a trademark protection. If there's a patent, maybe I can work on a provisional patent application. Maybe I can work out a plan where, okay, I'm not paying the full freight, but I'm paying part of it now, part of it later, breaking it up. There's strategy. We work with startups. We work out payment plans. We work out, to make it work, but there's an investment. There definitely is an investment. And I would say if you are a company, like I said, rule of thumb, you want to get to the point where 5 to 10% of your budget you're allocating to IP protection at a minimum. I know companies like Apple and Google spend, 6 figures on, one patent application, multiple 6 figures on one patent application. And they file like, 5 to 10,000 a year. So it's not, I know that's not within the reach of most of us. It may not be like that. It may be in the beginning, you are spending your first, the startup costs, your startup years, your first 3 years, you might be investing a lot in protection and certifications and building a business and business development. But then, it'll balance out, maybe by year 5, maybe by year 6, you are, 10% or 15% now. Or 10% now, you're able to manage those things. But you have to start. And I think, what I tell people is get started. Don't wait for the perfect time to get started. I've heard too many examples of, I was just going to do this, and you see it on a commercial or you see someone else doing it. And don't share your ideas unless you have no intention of protecting them. Because once you share your idea with someone, unless you have an agreement or something in place, that it's not your idea anymore, it's theirs. They can think about it and add to it and do whatever they want with it. And people feel betrayed or, taken advantage of, but if you don't share the idea, and I'm saying that not every idea is worth a patent or a trademark or at the same time in the same vein. I don't want you to think that everything I think of, I need to get a patent on. That's impossible. But certain things do make sense. And you want to make sure that you evaluate that. So one of the services we offer is evaluating patentability before you go down the rabbit hole of spending, tens of thousands of dollars on a patent. Is it even patentable at this stage? A lot of times things are good ideas, but it hasn't been fleshed out to the point where it's worth a patent. It hasn't been fleshed out where it's worth even the market investment. But so sometimes you need to start at that place and make sure you get clarity before you're too deep in to get out of it. you swim out too far to stop swimming. You're no longer by the shore, so you have to keep going. And so part of it, one of the things that we offer, and I think I'll either, if you have this, Jim, I'll send a link or send I might put it in the chat where you can do a call with us, and minimal investment, but basically a call with us to do a strategy, and we'll just kind of work through it, because you need to have an idea, you need to have some clarity, and that's the biggest thing, is to be clear on this stuff. Don't just react. You don't say, oh, I feel like I'm gonna lose my shirt because I told somebody this or that, and you spend all your money. No, you want to have a clear, concise understanding of the full picture. I know
Yeah, so Demetria wants to know, what questions should they ask when interviewing a copyright or trademark professional like yourself?
That's it depends. I'd say, you want to make sure you're talking to somebody that's competent and understands the process. You might want to ask them, some proof of that they've done it before, that they have some, you should be able to look their name up and find patents or trademarks or something associated with them. The other one says,
Oh, can realtor name and logos be trademarked?
yes. So if you're part of a company, a big, you're a realtor under a larger real estate firm, a national brand, usually they're already trademarked. But if you're building your own independent brand, like regardless of whatever real estate company you work for, you yourself, like, I'm the Maryland Realtor, or if you have some type of brand you're building for yourself, you want to protect that. So you can trademark that. There might be some, things to trademark, copyright. If you're developing an app that you're going to use to drive your business or to make it easier to deal with real estate, then you may want to patent it. I'm saying it just really depends. I can't give you one answer because I don't know your particular situation, but typically, yes.
What's a I don't know if it's an average cost, if it's a fixed cost in the state of Maryland, if you wanted to trademark something, what does that cost, and what does a copyright cost?
So it depends on what type you're getting. In fees alone, I mean, you can look, I don't know, people have different prices. I know that, we work with a Maryland law firm here in Baltimore to do our trademarks. So I'd say something like $2,000 per mark would be an average cost. With inflation, I don't know, those might be old numbers. It might be 3,000. I don't know what people are doing now to respond to inflation, but that's including filing fees of basically per application. It's going to be like between 225 and 275. And that's usually inclusive of that. That 2,000 will cover that as well. Also going to include a trademark search, comprehensive trademark search, as well as the application, as well as any type of correspondence with the patent office, unless you have a difficult mark. One of these more complex ones where you have to go back and forth and fight with somebody, that's going to be more than that.
Well, that's part of it, right? That search is part of it. And a lot of people say, well, I checked on Google and I didn't see anybody else with it. And they need to understand that that's not the same, correct?
It's not the same at all. I mean, you can do it. I'm not saying that. I mean, check every Secretary of State in the nation. Check every country in the world, all 150 plus. Go to all those databases. Go to every social media website. You can do that, or you can get with a professional that knows how to do it, has the tools to do it in an efficient manner, and can get that to you. There's no shortcuts in this. A lot of times I have startups I have to fix stuff, and I have people I had a startup, a really unique business, really unique product, cosmetic product. I could not get them a patent, not because the patent wasn't well written, not because it didn't cover the scope of it, because they filed a patent themselves 3 years before, and they came up with a better model. But the way they wrote their patent and what they put a Kickstarter out, they went public and all this stuff. That's the only thing that came up against us when we were prosecuting the patent. So why did y'all tell me y'all did this? Oh, well, it wasn't that important. I said, yeah, it's very important. The only reason, it's the only reason they couldn't get a patent. And I'm saying that that self-inflicted wound that cost them the ability to get a patent. So all that money they saved from doing it themselves created the the public record that prevented them from doing anything in the future when they did spend the money. So
Wow.
this is not something you want to, like, I can do plenty of things myself in this, and I still hire somebody else to do it. You know, if I have to get my trademarks, do all these things, because it's a different, when you have a professional doing it, what they say, make sure you have somebody you can sue. Make sure you have somebody that's responsible. Make sure you have somebody that has expertise. Make sure you have, I understand what that really is saying is making sure that you have someone that can help you and guide you through the process and is going to be accountable to do it.
Yeah, I agree with that. So we're coming up on time. In fact, we're a little bit over. I thank everybody for staying on the line with us. We have one quick question, if we can. Raquel wants to know if you can do this online. I think that's filing for a trademark or copyright.
So, well, this is one thing that's very clear. So a state trademark, like in Maryland, you get a trade name. My company, Patent Insider, is a trade name. That's not the same as a trademark. That only has something to do with registering a name in the state of Maryland. You can't sue anybody for that. You can't, a trademark is different. A trademark is federal. Trademark is federal. So I'll put a link here. Should I send this to, I don't know who to send the link to for.
You can send it to us and we'll share it. We'll share it with everybody that was online today.
Yeah,
and
or send
your
it to me,
contact
Tariq.
information.
Okay.
Yeah, send it to me, Tariq. I'll get it to Bunky and Lisa, and they can share it with anybody who needs it.
Yep, sounds good.
All right. Well, we thank you guys for your time today. Thank you, Tariq, for sharing all that knowledge, all that free
Yes.
knowledge.
Thank you
We
so much.
appreciate
That
it.
was
Thank
great
you, sir.
information. I know I learned a lot today. Thank you for
Yeah.
joining us. Thank you, Jim.
You're
Thank
very
you,
welcome.
everyone. And we'll send you the copy of this. So if you do want to go back and hear something again, you'll have it. So, and the people that weren't on will get it today as well. So we'll send that out and we'll send your information to Rick with a link.
All right.
Hey, guys. Thank
Bye.
you.
Thanks.
All right.
Thanks,
Thank you,
everybody.
guys.
Excellent training. Thank you.
That was pretty good, wasn't it?
Yeah,
Oh my
it's
God. It was
awesome.
the best. It was so informative.
He answered so many
sometimes-
questions.
Sometimes that format is really good. That what we call fireside chat, just having a conversation and allow people to ask all their questions.
Yeah, it
Usually
was awesome.
works out pretty good.
Well, definitely want to do that again sometime, Jim.
All right. All right. I got plenty of people to talk to, professionals, if we want to
Yeah.
set something like that up in some other,
Yeah,
capacity.
definitely. So we'll talk. We'll
All
get
right,
together.
guys. Have a good one.
Thank you.
Thanks.
Bye, guys.
Bye.